Hi there, Doc from BarcastAudio here today to talk with you about an MBE question of the day, a multiple choice question as tested on the bar exam. I'm going to run through this very quickly. I'm going to try to get through a couple of questions. I say one question, but I'm going to have a secondary question that kind of builds off of the law tested in the first question. So let's jump into this. Let's try to do this very quickly. I'm going to try to do a couple of these throughout the days as we're leading up to the exam. So let's jump right into it. Before we get started, be sure to subscribe to this channel. Be sure to check us out at BarcastAudio.com. Whether you are a law student, whether you're preparing for the bar exam, we have everything you could possibly need over there. Audio outlines, essay attack sheets. I'm setting up tutoring sessions as we speak. Check us out over at BarcastAudio.com. This is something new that we're trying. I know that you can follow along here with the quiz sort of answers, so I'm looking forward to checking this out, and let us know in the comments whether you enjoyed this video and whether you want to see us do more of these MBE questions of the day. So without further ado, let's talk this MBE question of the day. The question is as follows. An Amazon driver was driving along a lonely road on a very cold night. He saw a man lying in the field by the side of the road, apparently injured. The truck driver stopped his truck and upon examination discovered that the man was intoxicated and in danger of suffering from exposure to the cold. However, the truck driver returned to his truck and drove away without making any effort to help the man, who remained lying at the same place and was later injured when struck by a car driven by a traveler who, drowsy and inattentive, had veered off the road into the field and hit the man. The traveler did not see the man prior to hitting him. If the man asserts a claim against the truck driver for damages for his injuries, will the man prevail? A. Yes, because by stopping and examining the man, the truck driver assumed a duty to aid him. B. Yes, if a reasonably prudent person under the circumstances would have aided the man. C. No, if the truck driver did not in any way make the man's situation worse. D. No, because the man himself created the risk of harm by becoming intoxicated. So take a minute, think this through. I'm going to have the question or the quiz here on screen so you can sort of look through the question yourself and decide what you think the answer is here. So first off, when you see one of these questions, what I want you to think about is what is actually being tested. This is pretty clearly a torts question. They're asking you about duty and a breach of duty and negligence as tested by torts. This isn't an intentional tort situation. It's whether the driver of the Amazon truck owed this person they found on the side of the road a duty of any kind. And that can be a bit of a complicated issue. And if you don't know the law here, if you don't know the actual law itself, it's going to be difficult to get this question right. So when you're faced with an MBE question, I always say make sure you look at the call of the question, and that'll become sort of important, and you'll understand why that's important when I get into the second part of this. Because for now, the question here is whether the truck driver owed any sort of duty. And the question is sort of, by going out of the truck and inspecting this person on the side of the road, did they sort of impart some sort of duty upon themselves? The correct answer to this question is actually C. That is no, if the truck driver did not in any way make the man's situation worse. There is no general duty to aid another person. There are some exceptions to that general rule, however, one of them being if the truck driver had caused the original harm to the victim. 2, if the truck driver had a special duty, such as a child parent, or they were married, or any other sort of duty, like a doctor to a patient, that kind of thing. 3, if the truck driver had affirmatively acted in some way to aid the victim, thereby undertaking a duty to aid and complete that aid. So the facts here just state that the truck driver examined this person, but left him lying there. This guy did not affirmatively make the guy's situation any worse. The truck driver did not make the person he found along the side of the road situation any worse, and he had no general duty to aid this person. So because he did not make his situation any worse, there's no special relationship here, and he didn't make any sort of actual affirmative steps to aid this person, thereby taking on a duty to complete that aid, then C would be the right answer here, meaning that there was no general duty. He didn't have to help this guy. Now, with that in mind, let's talk about an identical question, essentially. It's going to be the same facts, but I want you to pay attention to the call of the question and let me know what is sort of different in this call. So an Amazon driver was driving along a lonely road on a very cold night. He saw a man lying in a field by the side of the road and apparently injured. The truck driver stopped his truck and upon examining, discovered that the man was intoxicated and in danger of suffering from exposure to the cold. However, the Amazon driver returned to his truck and drove away without making any effort to help the man, who remained lying at the same place and was later injured when struck by a car driven by a traveler who, drowsy and inattentive, had veered off the road and into the field and hit the man. The traveler did not see the man prior to hitting him. If the man asserts a claim against the traveler, will the man prevail? Okay, different question stem here. Now, the question itself, the call of the question is different, and it's notably different in that we talked about how important that is, what's actually being tested. Because at first, we're talking about affirmative duty to help someone. Again, a torts question pretty clearly. In the first version of this question you saw, if somebody just goes out and examines somebody, do they owe any sort of duty to the person? In this question, we're asking about the second party here, the traveler who veered off the side of the road, who was drowsy and inattentive. So let's talk through the question stem here again. If the man asserts a claim against the traveler, will he prevail? A, yes, because the traveler was negligent in going off the road. B, yes, because the man was in a helpless condition. C, no, because the traveler did not see the man before he was struck. Or D, no, because the man's intoxication was the cause in fact of his harm. So let's move through each of these. Again, it's torts, so you understand you're being asked about a duty and what duty this driver who veered off the side of the road while drowsy and inattentive may have owed to the person he hit. So yes, because the traveler was negligent in going off the course of the road. That's going to be the correct answer on this one, but let's go through the wrong answers first. B is yes, because the man was in a helpless condition. The helpless condition doesn't actually matter here. We're talking about duty and whether you owe a duty to another party. So realistically, only the two last sentences of our hypothetical really matter here. And those are, the man was lying on the side of the road and the traveler was drowsy and inattentive. And when he veered off the road, he was not acting the way a reasonably prudent person would have acted. He was acting negligently and affirmatively caused this person's injury. On C and D, it's sort of confusing, right? Because C is no, because the traveler did not see the man before he was struck. Ultimately, that doesn't matter because the traveler was responsible because he was negligently driving while drowsy and inattentive, and he owed a duty to the person off the road to not strike them with a vehicle, essentially, and to not drive in a reckless state. Now, D is also incorrect because the man's intoxication was the cause and fact of his injuries. It was not the cause and fact of his injuries, in fact. The cause and fact of his injuries was being struck by this car due to the traveler's alleged negligence, the driver's inattentive and drowsiness. Because of all of this, any claim against the traveler would be likely to prevail. That does it for today's MBE question of the day. Be sure to subscribe to the channel for more of these. Be sure to check us out at BarcastAudio.com. We have audio outlines, essay attack sheets, everything you need to pass the bar exam. We have it over there. Until later, I'll talk to you guys soon. Bye now.